Judge Garland, may I open court?
Please do. Thank you, Annie.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-5337, VoteVets Action Fund appellant versus United States Department of Veterans Affairs and Robert Wilkie in his official capacity as Secretary of the United States Department of Veterans Affairs. Ms. Jones for the appellant, Mr. Winnick for the appellees.
Ms. Jones.
Thank you, Your Honor, and may it please the court. Carianne Jones on behalf of appellant VoteVets. Your Honors, the issue in this case is this. What are the reasonable inferences to be drawn from the many, many factual allegations set forth in VoteVets' amended complaint, showing an extensive, coordinated, and continuous relationship between three private individuals who operated as a group to advise the Department of Veterans Affairs on a variety of policy matters over the course of a year and a half. Now, appellees and the district court below would turn this case into one of summary judgment, but it is not. VoteVets was not required at this stage of the litigation to prove up its claims. It was not required to make a probable case. It was required to make out a plausible case. And plausible, taking all facts as true in the complaint and drawing all reasonable inferences in VoteVets' favor. Now, Your Honors, I think it's important to start and really focus on what makes this case so unique. This is not a case like the one that the Supreme Court was concerned about in Public Citizen involving one-off consultations. This is also not a case like what this court was faced with in AAPS, where it described a group consisting of hundreds of different participants who didn't seem to really interact with each other, and what this court called more of a horde than a committee. Instead, what you have here is three private individuals who describe themselves operating as a team, as a group, who the White House describes operating as a team, as a group, who the department describes operating as a team, as a group, working in close coordination with each other to advise the department over the course of 18 months. This is truly a unique case, and a unique case, Your Honors, I might point out, that really cuts to the heart of FACA. FACA was passed because Congress was concerned that the executive branch not be allowed to, behind closed doors, seek this sort of formalized advice from private individuals. This is precisely that kind of case. This is consistent, coordinated, extensive interactions between a group of the same private individuals, the same three guys operating together to provide group advice to the department.
How do we know that the president or the agency established this group from what you have alleged in your complaint?
Sure, I think there are a number of facts that make it at least a reasonable inference that the president, operating in coordination with the department, established this group. And of course, the de facto FACA doctrine really is the totality of the circumstances, and particularly in the established context, courts look at, did the federal government conceive of the need for the group? Did they select the members? Did they task the group with their agenda? I think you see that in a number of ways. Our complaint alleges, of course, that President Trump met with these three individuals at the White House to discuss Veterans Affairs policy. He then announced shortly thereafter in a press conference that he was going to set up a group to advise the VA. Thereafter, Secretary Shulkin met with these three individuals and followed up with an email. The subject line was group meeting, in which he thanked the group of individuals for their willingness to help work with the VA. And then you see a course of conduct, 18 months of these same three individuals working very closely and coordinatedly with the department to actually advise it. So I think taking the totality of the circumstances and looking at all of the facts in context, it very much is at least plausible, it is at least reasonable to think that President Trump said, I'm going to set up a group. That group starts to operate, and the reasonable inference is that he did in fact follow through on his intention to do so.
Well, you cited in your complaint a ProPublica article, and that article said that Perlmutter set up the group, or at least fairly read, that's what it seems to say. So if that's the case, can't we use that article to help interpret what the plausible, I guess, what we can reasonably infer from your factual allegations, since you cited it?
Well, I think what that article makes clear is that it was certainly Ike Perlmutter's relationship with President Trump that sort of enabled this group to be brought into being, and that's acknowledged in the joint statement that the three individuals issued. But this is certainly not a case like in Food Chemical News or in Bird, where there's no involvement from the federal government in the establishment of the council, even if Ike Perlmutter played a significant role, perhaps in talking with President Trump about what this might look like. The federal government, our complaint establishes or alleges facts that do make clear that the federal government did have at least some involvement, and in fact a significant involvement, in conceiving of the need for the group, selecting the members, and sort of starting the group out on its task of advising the VA. I'd also point out, Your Honors, that of course we don't have to prove that the federal government established the council. We could also prove in the alternative that the federal government utilized the council. And we similarly think we've alleged sufficient facts to make that case plausible as well. Of course, utilized takes on a sort of unique context, or a unique definition in the FACA context. As this court has described it, citing Public Citizen, the question is whether the group is so closely intertwined with the federal government as to be amenable to strict control and management. But in understanding that standard, I think it's important to take a step back and look at the reasoning of Public Citizen. And what Public Citizen says is that utilized is essentially an extension of the term established. And it's meant in such a way so that FACA covers groups that are not only created by the federal government, but also created for the federal government. As the Supreme Court in Public Citizen sort of explains, the question is, did the government sort of permeate the group? I think that's absolutely the case here. There's no question that this group existed solely for the purpose of advising the Department of Veterans Affairs during this 18 months. This is very much unlike the ABA Committee, which of course is a separate, long-standing institution that has its own funding structures and its own priorities and its own work process flows. This was a group that was closely intertwined with the department. The department I'm sorry, Your Honor.
I didn't mean to interrupt you, but I had a question. You mentioned a couple of times that this group functioned for 18 months, and I wondered whether it's finished and whether, if that's the case, do we have any mootness issues?
Yes, Your Honor. To the best of our knowledge, yes, the group stopped functioning, I think back in sort of middle of 2018 to our best guess. However, this court made clear in Kamek v. Gore that Section 10 records claims under FACA are not mooted by the termination of an advisory committee. So we do think very much that our Section 10 records claims are very much alive.
So if they provided the documents, that would moot the case?
I think that our only claim for relief that remains live are the outstanding documents claims. That's correct. But
yeah, I'm sorry. Go ahead. I didn't mean to interrupt. I did mean, but it's only because of Zoom. Sorry. We're done.
No problem, Your Honor. I would just point out that there's been no contention here that the department has released the records it's required to release. And so I think absolutely that remains.
What's left after what you've already gotten under FOIA?
Well, Your Honor, first of all, I point out that just because the documents have been released to us under FOIA, the government's responsibility here is to make them public. I believe some of the documents have been put on the department's reading room, or at least were for a time, but it's not clear that they all have been and that they all are still there. I'd also point out that through FOIA, the department has searched the emails of government officials and the private emails of Secretary Shulkin. The government has never to this date searched the emails of these private individuals or seen what documents might have been shared amongst those private individuals. And that very much could turn up documents that would come within Section 10B's disclosure requirements.
I had a question about just the basic theory. And this is, as you mentioned, a kind of a different fact pattern, but it struck me that under Section 9, 5 USC App Section 9, the statute says no advisory committee shall be established unless it's specifically authorized by statute or by the president or by an agency. And in a way, I mean, the analytic effort of the briefing is, to fit it in, or the blue briefing is to fit it into FACA and basically say it is an advisory committee and therefore is held to the requirements. But it in a way, the allegation suggests a more fundamental problem, which is that this group operating as it's alleged to have operated would be unlawful. It isn't. It could not be a lawfully functioning FACA group. And so I'm just trying to make sense of how to understand that and how to understand your briefing in light of that.
Mm-hmm. And I do see I'm over my time and just want to make sure that I can quickly answer. So yes, I think the issue here is when you have the government creating behind closed doors a group to work extensively to advise it, as has happened here, that may raise significant FACA concerns and FACA violations as we allege, but that should not be allowed to sort of cover the government, or it shouldn't mean that the government didn't need to comply with FACA. I think what AAPS looks at is this the kind, this is de facto FACA doctrine. AAPS says, is this the kind of formal group that you would expect the government to only utilize or only work with if it's operating through the appropriate FACA channels? And AAPS also makes clear that FACA should not be read in a way as to become easy to avoid. And if it were the case that the government could avoid the requirements of FACA simply by setting up a FACA and giving it so much authority and operating in such an unlawful manner, that would essentially render FACA a nullity. So I'd urge the court not to accept that reading, to find that this was a de facto FACA advisory committee, and to allow the case to proceed on that. Thank you.
Further questions from the panel? Okay, in that case, we'll take this, turn to Mr. Winnick.
Good morning, Your Honor. May it please the court, Daniel Winnick for the government. The complaint doesn't come close to alleging a group with the sort of organized structure that this court described in AAPS as a key characteristic of an advisory committee. And even if the alleged group was structured as an advisory committee, the complaint doesn't plausibly allege that it was established by the government. Let me start with the nature of the so-called council. As the Supreme Court explained in Public Citizen, FACA was not meant, quote, to cover every formal and informal consultation between the president or an executive agency and a group rendering advice. It was meant instead to address the proliferation of a specific type of group rendering advice to the executive branch, the proverbial Blue Ribbon Commission. And to avoid constitutional concerns, the Supreme Court and this court have construed FACA as limited to those types of groups. As the court put it in AAPS, groups that have, quote, an organized structure, a fixed membership, and a specific purpose. That's why, for example, in the en banc decision in Cheney, the court described the right to vote on proposals or to veto a consensus as a hallmark of membership on a committee. The court said it wasn't enough to simply sort of participate in meetings or be there. What's alleged here is nothing we submit in the neighborhood of that sort of structure. When the complaint here describes a meeting of the so-called council, what it's generally talking about is, a phone call or a meal or a conversation of some sort between a VA official and one or two of the individuals alleged to have composed the council, in which those one or two people gave some advice. And plaintiff is suggesting that FACA applies to virtually every interaction like that.
Mr. Winnick, assume for purposes of this question that whatever degree of formality is required, that there is a group. Why isn't this combination of allegations sufficient for plausibility that it was established by the government? So you have an allegation supported by a Boston Globe article, which seems more than plausible. The information came from Sean Spicer. And that is that the president met with advisors about advising the Veterans Affairs Department, and that all three of these people were in the meeting, in the room. Then the president announces that we're going to be talking to a few people also to help David, at that point, putative secretary. We're going to set up a group, and then mentions Ike Perlmutter. Why isn't that enough for, I appreciate this is not enough for summary judgment, but why isn't that enough for it to be plausible that the president established this group, assuming that the group is sufficiently formal in the way that you were discussing?
Understood. So two distinctions, I think, with the sort of narrative as recounted in Your Honor's question. First, the December 2016 meeting between the president-elect and a group of advisors on veterans issues was a meeting that, according to the complaint and the public reporting, Perlmutter and Moskowitz and Sherman helped to convene. But it was a meeting between the president-elect and a group of healthcare executives, principally. And when the president-elect spoke the next month in a sort of vague way about creating a group to advise the VA secretary, what he described was, again, that same sort of group, a group principally consisting of healthcare executives and doctors, in which Ike Perlmutter, he didn't mention the other two, had been involved in the effort to create such a group, again, playing, according to the complaint, a convening role. So if this were a group that were sort of like the one described in the press conference, it might be a closer case. But fundamentally, this isn't the group described in.
Well, that's a question. So under Iqbal, it doesn't matter whether it's the only plausible possibility. I take your point that there's another plausible possibility here, but and that would certainly get you past summary, stop at summary judgment if that was all there was. But why doesn't this at least get the complaint, get past the complaint? Your argument is plausible, but it's also plausible that the group he was referring to included these three people. And that it was set up, as he said, to advise David. So it's just a question of plausibility. That's all that we're at the stage now, as opposing counsel points out.
Understood. So there are basically two reasons, Your Honor. The first, I think, is that there simply isn't enough factual basis in the complaint to make the inference that plaintiff is suggesting non-speculative. I mean, really, it is. When they say the president named Perlmutter the chair of the committee in Moscow. Okay,
I understand that, but that's a legal conclusion from the facts. But the question is, are the facts sufficiently plausible to indicate that the president or the president in combination with David has set this up? He said, we're going to create a group.
Well, so first of all, Your Honor, I want to make it clear that it's important whether it was the president or the president in combination with Perlmutter setting up this group.
No, I didn't mean with combination with Perlmutter.
You meant with Secretary Schulman.
That's the David I'm talking about.
Okay.
Is Perlmutter's name David also? I don't think so.
No, sorry, Your Honor. It's like.
And I don't mean to refer to David as, like I know him. No. But the president referred to him that way. So.
That's right. But again, I mean, the point I was getting was that it is crucial under this court's case law, not only that the government in some sort of loose way conceive of the need for a group in the way that plaintiff was suggesting, but that the government actually appoints the three members. And we think in fact the ProPublica article on which plaintiff relies defeats that notion. But the second response I had to Your Honor's, I'm sorry.
Oh, no, I don't want to interrupt the flow. Go ahead.
Just briefly, the second response is that Iqbal also says that even where a narrative might otherwise be a plausible inference from the complaint, its plausibility can be defeated by the presence of an obvious alternative explanation, which we think is present here as documented in the statement of the three men. I'm sorry, Judge Pillard.
No, I apologize for interrupting. So the district court, and I'm on JA 64, concluded that the allegations throughout the amended complaint that the three men exercised influence over the department, and I know this is on utilized and not on established, but to me, the two are kind of cross-cutting. The allegations that they exercise influence over the department undermines any reasonable inference that the department exercise actual management and control over them. And I wonder if you're defending that reasoning. And the reason that I raise it in connection with what you and Judge Garland were just discussing is that there are questions, sort of who took the initiative, And one way of looking at the facts alleged here is that it's actually even worse, that the utilized and the established is, do we even have the kind of relationship between the government and the private actors that implicates FACA? And here it seems like it's gone even beyond the cases that we've seen before, in the sense that these folks, let's say, and I'm not saying that I think that these facts allege it, but this is, I think, the theory underlying the complaint is 3 people get together, they say, we've got a lot to contribute. They approach the president says, gee, I think that's a great idea. And the 3 people are kind of an, external group that then has a controlling force over an agency. And putting aside whether you think these allegations rise to that level and are plausibly allege that, is that kind of activity something that implicates FACA or not?
It's not, Your Honor. FACA was meant to address a specific type of group. Again, the sort of proverbial blue ribbon commission. What Your Honor is describing, I understand, how it might be sort of concerning in a policy sense. It might implicate others, sources of law, such as, ethics laws or something like that. But it's not the sort of thing FACA was meant to address. As Your Honor is sort of hypothesizing, this is a group that was sort of exercising undue influence is almost definitionally not an advisory committee, certainly not one that is utilized by the government within the meaning of the utilized analysis. In other words, one that's operating under the close management or control of the agency or within parameters set by the agency.
So just to interject there, it seems like one way of understanding the close management and control arising in the context of the ABA advising on the qualifications of nominees is to sort of differentiate an outside entity just giving advice, take it or leave it. Here's our white paper. We think you should reorganize the VA this way. We think you should, these judges are qualified or not in these ways. And it's kind of here's this product, take it or leave it. And what the public citizen analysis is saying is that's okay. What's not okay is if the government's saying, here, let me outsource this to the ABA. We want you to look at these various criteria, and you're going to tell us to meet our needs whether these people are qualified or not. And the latter seems to me what public citizen is concerned about when it's talking about direction and control. But if the government just said, we don't even have criteria, ABA, you tell us what judges we should pick and actually what criteria we should use, it seems to me the abdication of control and direction by the government in that situation wouldn't take it out of FACA, which is a little bit what I take your argument to be suggesting, but rather put it more squarely in under FACA.
So I think that if the group is of the sort that FACA was meant to cover, then certainly the exercise of undue influence by such a group, does implicate FACA. But our central point here is that this isn't the sort of group FACA was meant to cover. And I would note, as this court has said in AAPS and Cheney, and as the Supreme Court said in Public Citizen, it is both a matter of long historical practice and close to the heart of the constitutional protection of the executive for the president and other senior executive officials to be able to solicit advice on any subjects that they wish from people outside government. So, if as plaintiff alleges, the president said, I want Ike Perlmutter to provide lots of advice on veterans affairs, and I want my secretary of the VA to take his advice quite seriously, not literally to be sort of bound by it in a legal sense, but to hear it. And I consider him a wise advisor. That is exactly the sort of thing the president is constitutionally empowered to do.
And is he not does it not bring it into FACA if he says, I want Ike and these other 2, I want them to be a group, an interface with doctors and healthcare professionals, decide some priorities for us, and come back to me with that? Is that similarly just the president drawing on outside advice in a way that doesn't implicate FACA?
I think that's correct, Your Honor. I mean, to the extent that what Your Honor is highlighting is that it's a group and not a single individual. I think, again, if we were applying the sort of the structure analysis of AAPS to look at whether this was the type of entity that FACA was meant to cover, then the fact that there's more than one person would be a prerequisite. But it's not sufficient that there be more than one person in a room. They have to be, as the court said in Cheney, they have to be voting on things. They have to be coming to formal consensus. The fact that you have two people or three people instead of one person providing advice as individuals, or even in some sort of loosely affiliated sense, isn't enough to be covered by FACA. And on the broader question of whether Congress was sort of meaning to, in a kind of broad way, subject the whole provision of advice from outsiders to insiders to strict, requirements. And what the court said in Public Citizen, I think, usefully is there's considerable evidence, and I'm quoting, that Congress sought nothing more than stricter compliance with reporting and other requirements, which were made more stringent by advisory committees already covered by a prior executive order and, quote, similar treatment of a small class of publicly funded groups created by the president. In other words, it was trying to impose stricter requirements and to heighten enforcement of those requirements for a small class of groups, a particular type of group. It wasn't meaning to impose, stringent procedural requirements and sunshine on all kinds of the provision of advice to people in government, whether by one person or, as Your Honor suggested, a small group of people. Had it done so, I think both Public Citizen and this court's cases have suggested, real constitutional concerns would arise.
All right. No further questions. We'll give Ms. Jones a chance for rebuttal. Why don't you take 2 minutes?
Thank you, Your Honor. I just want to make a couple of quick points. First of all, opposing counsel raises Cheney several times and says that this wasn't the kind of committee that would be considered an advisory committee under Cheney. Cheney was very specifically related to a White House advisory committee, and the court in Cheney was clear that the reason it was imposing this voter veto standard was because the president does have this understanding, is understood to have a little bit more leeway to seek advice. And so the standard needed to be higher. No court in this circuit or any circuit from my knowledge has ever applied that heightened voter veto standard to advisory committees that are principally advising the department. And I also think just that principally advising the department point is important. Opposing counsel again says this isn't the kind of committee that was meant to be covered by FACA, and the president has a lot of authority or a lot of sort of leeway to seek advice. This wasn't principally a group that was advising the president. This was a group that was advising the department and working with the department officials daily to advise them on not just one matter, but a whole number of very important matters, including being involved in a procurement process for a multi-billion-dollar contract that the department was in the process of developing. This is exactly the kind of thing that FACA was meant to prohibit.
So what are the minimum criteria in the sense of, is it the group character? Is it the ongoing nature? Is it the apparently maybe it's the fact that these people seem to have so much authority because they were understood to be blessed by, at least as the allegations have it, blessed by the president, which again is a little bit of an awkward fit with some of the doctrine on utilization. What are the minimum hallmarks in your view?
Well, I think the minimum hallmarks are probably all of the above. I think what you have here is a fairly egregious case involving the same three individuals operating as a group, advising continuously over the course of 18 months, and advising on important issues, and seeming to wield a significant amount of authority. I think that doesn't make this not an advisory committee. That just makes this an illegally operating advisory committee. But I do think, again, it's this consistent, coordinated, ongoing relationship, the precise kind of thing that FACA was passed to prohibit: the unfettered use of groups of private advisors by the executive branch outside of any scrutiny by Congress or the public.
Further questions from the bench? All right, we'll take this matter under advisement. We appreciate this is a very, very nicely argued, and we like the tenor of the argument as well. So we appreciate that from both of you. All right, take the matter under submission.
Case number 19-5285, Stand Up for California et al. Appellants versus United States Department of the Interior et al. Ms. McLean for the appellants, Mr. Toth for the appellees Department of Interior et al., Ms. Ellsworth for the appellee Wilton Rancheria, California.
All right, Ms. McLean.
Thank you, Your Honor. Good morning. May it please the court. I'm here on behalf of appellants Stand Up for California, Patty Johnson, Joe Teixeira, and Lynn Wheat. This case involves a trust decision that was made by an unauthorized federal official without meaningful public review for Indians that are ineligible for trust land hours before the inauguration in 2017. In 2013, the Wilton Rancheria applied to have 282 acres of land in Galt acquired in trust for a casino. The department and the public reviewed that application for 3 years. 2 weeks after the 2016 election, however, the Principal Deputy Assistant Secretary, Larry Roberts, asked the state, local governments, and a few—
Can I just ask, you're presenting this as if this is one administration did something on its way out, but in fact, the succeeding administration certainly indicated that it had no problem with that. I appreciate the issue of whether it's ratified or not, but Trump administration, including its deputy secretary, to the extent that he could, tried to retroactively ratify this. So this is not, in tone anyway, this is not a case of one administration slipping something in as it's leaving. Isn't that right?
Well, no, Your Honor, I guess I would disagree that it was a case where one administration was trying to get something in without having gone through the—
But it is true that the next administration said it was ratifying. Now, whether—
No, Your Honor, the next administration, as an initial matter, the documents that the government has referred to are not part of the administrative record.
I'm assuming that they are. They're public. They're legal documents ratifying for purposes of I'm going to use the word ratifying. Isn't the next administration and the next administration is defending this? So this doesn't seem like it's something that this is a dispute between administrations. Maybe I'm wrong. I'll ask the Justice Department.
Oh, I don't mean to suggest—
but it seems like they are.
I'm sorry, Your Honor. I didn't mean to suggest there's a dispute between the administrations.
Okay.
My point is that, first of all, with respect to those documents, the February 10th document doesn't say anything about ratifying the principal deputy's decision.
I understand the words ratifying, and I didn't mean that. I know you have a dispute about that, but I just wanted to be clear that this is not a dispute between two administrations.
No, I don't mean to suggest it's a dispute between two administrations.
You can go ahead with the argument. Go ahead.
And just another limited detail. You did say that they were outside the record, but if we're referring to the Connor memo and the Black decisions, those were exhibits in the district court. They're in the joint appendix.
For purposes of our preliminary, we had a preliminary dispositive summary judgment motions in which we attached those documents after having gotten them from the Department of Justice per our request. We did ask to have those documents and the administrative record associated with those documents produced. The government opposed that and said that because the January 19th decision was final on its face, there was no reason to produce an administrative record for anything that came after January 19th. They were successful in that, and there's been no administrative record produced for anything that occurred after January 19th.
So that really goes to this question of finality versus availability of further administrative action.
Well, yes, Your Honor, the government has taken the position, the department originally took the position that the decision was final on January 19th because the principal deputy was exercising the authority of the assistant secretary. And the department's position is that the regulations, which only allow the secretary and the assistant secretary to issue final trust decisions, doesn't preclude the principal deputy from issuing final trust decisions. That is the position they've maintained in the litigation, and it is also the position that they set forth in the July 10th memorandum. Right. However, since then, it appears now that the department is largely relying on this ratification notion, both for the Connor memo, which also does not appear in the administrative record, and for the through the February 10th and July 13th memos as well.
Okay, just limited to the memo of Deputy Secretary Connor. If I'm understanding it correctly, their view is, well, first, your view is that 25 CFR 151.12c, by naming the secretary and the assistant secretary under the reasoning, a kind of expressio unius per Giordano, prevents any other delegation.
That is our position. In 2013, the department revised the Part 151 trust regulations to establish that the secretary and the assistant secretary have the authority to issue final trust decisions. That's in 151.12c, and that the BIA officials have the authority to issue non-final trust decisions.
Right, and then, but their position is that it's not so limited, that delegation is presumptively permissible, relying on international telecom. And if we were to agree that this is more like international telecom than like Giordano, in the sense that in Giordano, under, for a wiretap, it's very strongly, very narrowly controlled, but this is not that kind of decision. It's more like presumptively delegable. Then your position there is?
Well, I think, Your Honor, the first question is the regulation clear on its face? And the Supreme Court advised in Kaiser that you use traditional methods of statutory interpretation when interpreting regulations.
But I was just by hypothesis taking it beyond that and saying, if we don't think the negative inference on the face of the regulation, without it saying only or exclusively these two offices, that, and assuming that there is some permissible delegation, then the question is, was a delegation permissible for this agency, and or was a delegation made in this instance?
I think that we have, and I want to make sure I'm responding to each of your questions. So we don't believe that there was a legal delegation at all to the principal.
Right. So putting aside your language of the regulation, putting aside that argument just for purposes of parsing the steps, the next step in their argument is that under the department manual, in the absence of the assistant secretary, the principal deputy assistant secretary can authorize a delegated authority. And your response to that is
that the manual is specific about when the principal deputy can exercise that authority, and it has to be in the absence of the assistant secretary.
Whereas here, the position's vacant, and you say those are two different things.
They are two different things. And that's
the government responds that argument was not, that particular argument about the difference between the word absent and vacant was not raised in the district court and was forfeited. And I followed that, and I wonder what your best site is for where you think it was preserved.
Well, Your Honor, I think the clearest statement of it was during oral argument. It was not clear during the proceedings that the United States, our argument had focused on 151.12 in the plain meaning, and that was the response of what the federal government and the tribe responded to. During the proceedings before the court, when it became clear that there was confusion about the word vacancy versus absence within the department manual, we addressed that directly during oral argument. But our position has been throughout that manual provisions 8.1 and 8.4 are not sufficient to grant the principal deputy the authority to issue this decision.
Right. I understand that's your principal argument. And the ratification by Secretary Connor saying, "Oh gosh, we meant to say Larry, what's his name again, Roberts, and we gave him the wrong title, but we mean Roberts, and here's his correct title." That fails to cure, in your view, because
Deputy Secretary Connor's memorandum is not a legally appropriate delegation under the department manuals. The deputy secretary has to follow certain procedures in order to delegate the authority of the secretary. Those procedures include publishing the delegation in a department manual release, having the secretary's approval on the delegation, and identifying the specific authority under which that delegation is taking place. And the Connor memorandum does none of those things. Apart from that, the Connor memorandum was issued prior to the trust decision on January 19th. During oral argument, the Department of Justice represented that it had been issued earlier. So there's no basis, certainly, to claim the Connor memorandum ratified.
Well, it could be ratifying the delegation as opposed to the decision, which in some sense is actually stronger for them as opposed to weaker, because it's saying we really mean you, Roberts, to be empowered in this category of actions, and then Roberts takes an action.
I would say that the deputy secretary is still obligated to follow the procedures that are set forth in the department
in the manual. Now, their response, the tribe says in its brief at 38 to 39, these are kinds of internal formalities that are really up to the agency. And yeah, maybe they didn't adhere to them, but there's no private right of action on that. It certainly doesn't render the outcome illegal in any way that violates appointments clause or law or regulation. So, it's just not something that we as a court could pass on. And your best response to that is?
Well, we would come back to the plain language of the regulation, of course. But apart from that, the delegations are important because they're a way of ensuring that the decision makers are exercising the authority in a legally appropriate way. And when those delegations take place in a manner that's inconsistent with the manual, the public can have no idea how they've been granted that authority, from whom, whether that authority was valid, and it leaves everyone uncertain as to whether a decision, for example, is final or non-final. And if we had assumed, for example, that the principal deputy's decision was final, but if you look at 25 CFR 0.2, section 2.4, it says that the IBIA has the power to hear appeals from any deputy's decision. We could have missed the deadline for filing an administrative appeal, and then our rights to ever challenge a decision would be lost.
Although didn't you seek to file an administrative appeal, and then it was clarified then that actually this was somebody acting as assistant secretary, and therefore, I mean, isn't that what happened?
No, that's not. We actually reached out to the department after the decision was issued and asked under what basis they were claiming that this decision, which was signed by the principal deputy, not by the assistant secretary, right, how that was final. We received no answer. At a certain point, we concluded that it was necessary for us to file an appeal to preserve our rights. So we filed an appeal before the IBIA, the Interior Board of Indian Appeals. The board then asked the parties to brief whether they believed that the decision was final or non-final. At that time, the acting assistant secretary, Indian Affairs, Michael Black, who is acting pursuant to a delegation of authority from the acting secretary, assumed jurisdiction over the appeal pursuant to section 2.20, at which point we waited until the department until Black ultimately issued a decision on July 13th, saying that the January 19th decision was final.
And I assume you also filed a protective did you do something to kind of like protect your rights in the interim, or you just relied on that decision as the July 13th decision as kind of starting the clock, as opposed to January 19th starting the clock to file an action in district court, or did it matter for your kind of statute of limitations purposes?
No, well, Your Honor, what we did was we went to the district court and sought a temporary injunction or a TRO prior to the decision being issued. When it became clear, based on the timeline and the abbreviated comment period or comments for the NEPA review, we asked the court to enjoin not the decision itself, but the transfer of land into trust based on that decision. At that point, that was, I believe, on January 10th, the department represented to the court that I did not know whether a decision would be forthcoming or what that decision would look like. On that basis, and for other reasons, the district court denied the relief that we sought. We then filed a request under 705 of the APA, asking the department whether it would stay the effect of its decision, namely not transfer title to the land in trust, until we had the opportunity to return to court once a final decision had been made. That decision was pending, and the department then acquired the land in trust, transferred the land in trust on February 10th before we could go back to the court and seek relief because they had not yet denied our 705 request. So we already had an action pending in court at that time. The statute of limitations that applies actually with respect to challenging a trust decision is 6 years. So there wasn't a timing issue for us to go to court. But we had tried in many different ways to try to stay the effect of the decision prior to July 13th.
Just so that I can understand your position with respect to the presumption of delegability, you believe that it does not apply to regulations as the same way that it applies to statutes, right? That's your first position.
Well, I think that this court's never squarely addressed the issue, and that the rationale for the presumption of regularity has less force in the context of agencies, because when Congress passes statutes, it's not going to take the time in most cases to identify specifically who will be responsible for implementing what. So the presumption of delegability makes a lot of sense when you're looking at statutes. Within the agency, particularly after an agency has promulgated a rule, there's far less reason for that presumption to apply. And in this case, there's no reason for that presumption to apply because the rule specifically identifies and delegates to certain agency officials who has the power to make a final trust decision and who has the power to make non-final trust decisions. So there's no basis for applying a presumption of delegability in that context.
Now, courts have applied the presumption of delegability to statutes, even, I guess, without respect to whether the statute was ambiguous, right? The courts haven't said, well, if the statute we think is generally speaking clear and unambiguous, then there will be no presumption of delegability. That hasn't been how that's worked, has it?
No, no, courts have not done that.
So, but you're saying that we should do that with respect to this regulation because this regulation is clear and unambiguous.
Well, when a regulation specifically identifies the individuals that have the authority to make certain types of decisions, there's no longer the agency has already done the work for you. There's no reason to apply a presumption when the agency has specifically identified who is going to be responsible for what types of decisions. Applying the presumption of regularity in this context actually can undermine or negate the Secretary's authority. If the Secretary goes through the rulemaking process and is specific, as he was in this particular case, where the preamble to the rule makes clear that its purpose is to delegate to two officials, and two officials, only identified in there, final trust decision-making authority. Applying a presumption undoes what the Secretary's
well, that's sort of that seems to me an argument that the Secretary can make. That I'm not sure that you have a standing. I don't mean in the constitutional sense, but the Secretary here apparently doesn't agree with that point. The Secretary doesn't believe that the Secretary has been undermined by this. Of course, if the Secretary were taking the position that the previous administration had undermined the Secretary's authority, or some underling in his own administration had done that, there would be an argument. But I don't really see that you're in the place of claiming that applying the presumption in this case undermines the Secretary's authority when the Secretary doesn't think that.
The department may defend a decision that it's made, but that doesn't necessarily reflect what the language of the regulation requires.
I understand that argument. Let me ask you, is there anybody else on the panel who has further questions?
Thank you.
Not at this time.
Okay, great. We'll give you a chance for rebuttal at the end.
Thank you.
All right, and now we'll hear from Mr. Toth, correct?
Good morning, Your Honors, and may it please the court. Brian Toth for the defendant's
Toth, I'm sorry.
Not at all. Not at all. This is one among a number of cases that have been brought by the same lead plaintiff, including in this court, challenging the Department of Interior decisions to acquire land in trust for often, like the Wilton Rancheria, previously landless Indian tribes in California who were unlawfully terminated half a century ago and restored to federal recognition through a settlement. I got to focus, as my friend on the other side did, largely on the delegation issues, but I just want to mention, I think the California Rancheria Act claim and the NEPA claims are fairly covered by the case law from this court. In particular, the North Fork decision, I think, controls the case as to the California Rancheria Act claim. And on NEPA, I think looking at the Supreme Court's decision in Marsh provides the rule of reason that is flexible enough to accommodate the type of procedural path that happened here under NEPA. So turning to the delegation issues, the district court correctly held both that the regulation did not restrict redelegation authority and also that there was a redelegation, in fact, in this case. Now, on the first issue, whether the regulation is exclusive, the issue is it comes down to four main factors: looking at the presumption, the plain text, the purpose of the regulation, and Interior's past statement as well. All of these factors considered together weigh in favor of concluding that the regulation does not restrict the Assistant Secretary in acquiring land into trust or prevent redelegation.
I'm trying to understand your argument. When you say, when we try to determine whether a function is exclusive, do you mean that in the same way that the Federal Vacancies Reform Act uses the term exclusive or non-exclusive?
Yes. That's how this case, the arguments on appeal based on the regulation, that's how they fit with the Vacancies Reform Act. It's not disputed that this decision was made during a period where there was nobody who was an acting official for the Assistant Secretary, so that office was not occupied. Nevertheless, the Vacancies Reform Act permits, it's silent on, because it essentially carves out those responsibilities that are not required by statute or regulation to be exercised by, in this case, the Secretary or Assistant Secretary and only by those officials.
Well,
So-
what do we do here where the definition of secretary in the regulations is secretary or authorized representative, I think it is. And then you have the regulation here, section of 151.12, I think it is, that identifies the secretary and the authorized representative of the secretary who have the authority to make final trust decisions. Why should we presume that it would go any further than that based on that plain language?
I believe that you can read the definition of secretary in 151.2, I think it is, as a redundancy. In light of the purpose of and the text of 151.12, if you look at the overall structure of 151.12, well, let's just take the text. First of all, it doesn't expressly restrict redelegability by the assistant secretary. The argument that I believe Your Honor is referring to is based on a canon against construing the regulations to avoid surplusage. And that's a way of looking at the silence and trying to figure out what the silence in 151.12 means. But I would submit that a fair reading of the regulation and looking also at the purpose of the regulation, not only does the regulation not include any express restriction, but the amendments that were that led to this 151.12 in 2013, they were in response to an entirely different issue than redelegation. They were undertaken largely in response to the Supreme Court's decision in Patchak, which held, contrary to the government's longstanding view, that land into trust decisions were judicially reviewable under the APA. The prior regulation had included a 30-day waiting period to accommodate litigants who wanted to challenge those, consistent with the government's previous position that there was no judicial review once the land was acquired in trust. There was no longer any need for that 30-day waiting period, so that was the motivation from promulgating those regulations. At the same time, the regulations seek to inform challengers what paths they have for administrative review and how they can get to court. The regulations imposed expressly an exhaustion requirement. So yes, I would agree with my friend on the other side that it's important for them to know what their administrative appeal rights and avenues are. And the regulations do talk about two general paths in the decision-making, one by the secretary, one by the assistant secretary. But where there's no assistant secretary, nobody who is acting for that person, I think the regulation accommodates redelegation. It certainly doesn't restrict it.
Well, it accommodates redelegation in 151.12D, certainly. But why shouldn't we read all of that to mean if it's redelegated further, then that's construed as being redelegated to a BIA official, and that's non-final. I mean, that makes all of this harmonious, right?
So if I'm following you, in this case, Mr. Roberts was not, in fact, a BIA official. I apologize if I'm misunderstanding the thrust of your question here, but he was he was a principal deputy assistant secretary in the office of the assistant secretary.
Right, but let me just interject there. One of the things that the challengers here raise is that the regulations expressly say that a principal deputy's decision qua principal deputy, meaning not if he's acting as the assistant secretary, but when he's principal deputy, that also may be appealed to the board under 2.20C. So I think part of the difficulty here in terms of notice of which route has been taken, the administratively appealable route or the final route, is that this decision was signed by Roberts and doesn't say that he's doing it in his role acting as the assistant secretary. Is that the case?
So I think the best response to that, I'm not recalling the signature block on the actual decision by Mr. Roberts, but I would point the court to JA 2457. It's the Federal Register notice for the notice of availability of the final EIS. There, Mr. Roberts, above his signature, he says this notice is in the exercise of the authority delegated to the Assistant Secretary, Indian Affairs, by a department manual provision he cites.
Which column are you in? Wait.
I don't have the page in front of me. It's at the very end, the last paragraph.
Oh, yeah.
Signature.
Okay, yeah. So the signature itself, he says Principal Deputy Assistant Secretary, but a couple sentences above that, it says, is in the exercise of authority delegated to the Assistant Secretary, Indian Affairs, by 209 DM8.
Yes. I understand the point about the regs pointing in different directions with the appeal regs. I mean, that's a different part of the, or a different subpart of the Code of Federal Regulations. I don't think in this case that the plaintiffs were actually deprived of any administrative review. They sought an administrative stay under 5 USC 705, the APA. That was denied in writing. They later sought an administrative appeal. That was dismissed, also in a lengthy written decision with the reasoning that we're defending here. So, I think if they're making the case that there was confusion or that they were deprived of some procedural right, they weren't. They attempted to exhaust their administrative appeals. They did it protectively. Turns out the department believed they were wrong and dismissed the appeals, but they still went to court. They were not out of time. They were challenging this, as my friend says, even before the decision was made, they were seeking a TRO.
So can the department redelegate the authority to a BIA official and have them standing in the shoes of the Assistant Secretary and make a final decision for the agency?
A BIA official who would be delegated the authorities of the Assistant Secretary?
Yes.
That's a good question. I don't know the answer to that. I believe that they could, and I think the reason why is this reorganization plan number 3 of 1950 at JA 2689. It was confirmed by Congress in a public law in 1984. It provides that the Secretary of the Interior may make such provisions as he shall deem appropriate, authorizing the performance by any other officer or by any agency or employee of the department of any function of the Secretary. I mean, that's maybe 4 uses of the term any, 3 or 4. It's fairly broad, fairly encompassing. And
So you believe that
I'm sorry,
someone
what were
who's
you-
not an officer of the United States can make a final decision taking land into trust and depriving states of rights and authority and power on behalf of the United States, and that raises no constitutional problems?
I don't believe it raises constitutional problems. This is something I have looked at preparing for the argument, but we didn't quite brief this way. I mean, what we said in the brief is that the constitutional issues require some sort of supervision for the person to be an inferior officer. But we didn't brief the question of whether someone temporarily exercising delegated responsibilities of an officer must be an officer. And if I'd be happy to provide supplemental briefing on that. I think that's another way of looking at this, because the path, Judge Wilkins, that you're describing, the second path to decision-making under 151.12D by a BIA official normally leads to an appeal to the Board of Indian Appeals, which is made up of individuals who are they're not Senate confirmed, certainly. And they've recently been appointed by the Secretary. But I think what the plaintiffs are arguing for here is that they're entitled to some Senate confirmed decision maker, which they clearly are not. And I don't believe that although we didn't brief it, I'd be happy to provide briefing on the question if ordered. I don't believe that even an officer is required to be a constitutional officer to temporarily step in and be delegated the responsibilities of an officer of the United States.
How are we supposed to see your argument as doing anything other than undermining the Federal Vacancies Reform Act. Because if we basically say that pretty much any obligation of a Senate confirmed official is non-exclusive because the agency can redelegate it and there's a presumption that they can do so, then, you know, the Federal Vacancies Reform Act is essentially a dead letter, because even if, as in this case, the time period passes, the agency, it doesn't matter. The agency can still function and just make the person who Congress said couldn't be the acting official anymore, just continue to be the acting official because they're just going to delegate the authority to them. Why isn't that problematic?
Because they still cannot exercise the authorities that Congress makes exclusive to the official who's no longer occupying the office. And if Congress wants to change those laws and, you know, build into more statutes a restriction that only a certain officer or only a certain employee may exercise authority, it's free to do so. But for 20 years, under the Office of Legal Counsel has taken the view that because the Vacancies Reform Act does not cover, it defines out, if you will, the non-exclusive responsibilities, not only ones that are not exclusive by statute, but also, like here, ones that are not exclusive by regulation. It's simply silent. It simply does not restrict the government's ability to continue to perform those authorities through those functions through redelegation.
So you think that the only way that something can be deemed exclusive is if Congress explicitly says so?
Or if there is a regulation that makes that clear, and I think doing so explicitly would be the easiest way to do that. And we'd submit that this is not the type of regulation here.
So the agencies, the executive gets to decide when something is exclusive by how they write their regulations, and they can just write the regulation to make everything non-exclusive. That's the way you think this works?
They couldn't if there were a statute that made the responsibility exclusive. And to do that, a statute, as we know from Giordano, doesn't have to include express language, but there does have to be a compelling purpose behind the statute to limit redelegation. And while we think this regulation here, I mean, we think the same types of statutory principles can easily be applied to interpreting this regulation, but we don't think that there is a compelling purpose behind this regulation of restricting redelegation. Certainly, it provides information about two general paths to ordinary decision-making and the appellate rights and consequences for judicial review that follow an exhaustion, but that is not a restriction on redelegation, and we would ask the court not to read it as such.
I have a question about Doolin in our case law about ratification. My reading of Doolin is that an officer can kind of ratify an act that was previously taken so long as the officer at the time of the ratification has the authority to take the act, to perform the act him or herself, but also that the officer at the time that the decision was made, looking backwards, would have had the authority to have stood in the shoes of the actual decision maker and perform the act. Is that understanding of Doolin correct?
I believe so. And I think Doolin was reiterating basic principles of ratification under contract law and such. So I would agree with that. And I believe that, I'm sorry.
So let's just take the Connor memorandum. So could Connor, under Doolin, ratify the action of Roberts?
Yes, because as the deputy secretary, his office was in fact superior to the assistant secretary, Indian Affairs. And moreover, he acts with the full authority of the secretary. under the department manual provisions.
But what about the regulation? The regulation doesn't say, 151.12 doesn't say the secretary or the deputy secretary or the assistant secretary for Indian Affairs. It just says the secretary or the assistant secretary for Indian Affairs.
Right. No, I understand. And secretary, I mean, we talked about this a little bit at the beginning, being defined as or authorized representative. We'd have to argue that under the regulation, he was another authorized representative.
But the deputy secretary did not purport to ratify any of Roberts's actions, right? You're not arguing that this was an actual ratification here.
He confirmed, so that looking at the memo at 276 of the joint appendix, he confirms the delegated authority that Mr. Roberts had. And he says, to the extent it is determined you lack such authority, I hereby ratify and approve any actions you've taken. Our trial counsel stipulated or made a proffer based on non-record facts that we stand by during the trial proceedings, that the decision being challenged here came later in the day, on the same day than the Connor memorandum. I would have never known but for that proffer. We stand by it, but we don't think it matters because this is demonstrating the evidence that the department intended to vest Mr. Roberts with the full authority, the delegated authority of the assistant secretary.
And I guess I'm also trying to understand exactly the government's point of view here. How are documents that you are insisting are not part of the administrative record documents that we should rely upon at all?
So to be clear, Judge Pillard was correct in identifying them as, although not part of the administrative record we produced, part of the record on summary judgment that was properly before the district court and is properly in the joint appendix for this court. But as far as them not being in the administrative record, these are documents that we're relying on to cure an alleged deficiency in delegation. And as such, I think, Doolin in footnote 11 rejects the argument against ratification, that ratification is somehow a post hoc rationalization, saying that, well, ratification just simply cures the alleged deficiency. If there's a deficiency, the court doesn't need to determine that. But it's not providing a different basis for the agency's decision, which is really the point of the administrative record rule, to avoid the types of concerns about post hoc rationalizations. So I realize that's a lengthy answer, but I don't believe that the fact that it's not in the administrative record prevents us from relying on the document as a matter of, say, harmless error or curative arguments.
Thank you.
All right, we'll hear from Ms. Ellsworth.
Good morning, Your Honors. Jessica Ellsworth on behalf of Wilton Rancheria. Picking up on your question, Judge Wilkins, about the documents that counsel for the other side said were not part of the administrative record, I think it's important to understand how this case developed in the district court, which is that the plaintiffs moved for summary judgment on this claim of non-final decision before there was an administrative record. They moved for this and said their claim did not depend on administrative record and was independent of, didn't need to wait for, should be resolved before any administrative record was produced. All three of the documents, the two decisions by Mr. Black and the Connor memorandum, were included by the plaintiffs in the summary judgment briefing. They are what was before the district court when Judge McFadden had to decide if this was a final decision. So whether or not they were in the later produced administrative record to resolve different claims is really irrelevant to this question about whether they are properly considered on the claim for which they were submitted when the district court looked at them. Secondly, I heard Stand-Up's counsel tell Judge Pillard that one of the problems is that people won't know if a decision is final, if a delegation is permitted beyond the ASIA. That's not true for a number of reasons. And I think Stand-Up's own conduct here shows that they knew the decision here was final. It said on its face that it was final. And if a decision is not final, the regulation specifies that it has to be accompanied by information about how to administratively exhaust. So if that information isn't provided, then the time for filing an administrative appeal doesn't start running. And there are certain notice provisions. That's really what 151.12 was designed to do when it was promulgated in 2013, was provide some additional clarity to parties about these two paths for trust decisions that are in fact the same two paths that Interior uses for all of its other decisions. I think that's critical to understand when looking at this delegation issue.
But if a decision doesn't say by the author, I am signing this under authority delegated to me as the Assistant Secretary for Indian Affairs, as if I am the Assistant Secretary, then how is a party at that time going to know that that decision is not final? I'm sorry, is final, as opposed to a decision that falls within 151.12d?
So, Your Honor, I think one of the principal reasons is if you look at 151.12 C2 III, it includes information that has to be done for a final decision when it approves a request. And that what it requires to be done is that the land is immediately acquired into trust on the date, on or after the date the decision is issued. And this decision specifically directs that the land be immediately acquired into trust.
I understand that they acted as if it was final, but whether, just because a party acts as if they're complying with the law doesn't really control whether they really are. If the regulation says that the only person who can make this decision is the Secretary or the Assistant Secretary for Indian Affairs, and the person who makes the decision doesn't purport to be either one of those.
So, Your Honor, two responses to that. The first is that I think the Mango case from the Second Circuit and the Ethicon Endo case from the Federal Circuit are very helpful in understanding that the mention of a particular individual is not an exclusion of delegation to others. And I would suggest that those courts and the way that they distinguish Giordano is very useful for this case. The other decision, there's a Crawford Hall decision from the Central District of California looking at a different subdelegation by the ASIA, in which the court reaches a different conclusion about that provision, but spends pages explaining why the subdelegation here was properly done. And it goes through a number of factors, including this presumption that you were discussing with Stand-Up's counsel. And I think the presumption is one of the factors that weighs in favor here of subdelegation.
Should there be a presumption when you have a Federal Vacancies Reform Act that Congress, puts limitations on the executive's abilities to have acting officials based on exclusive functions? So we're supposed to have a presumption that nothing that officials do is really exclusive?
So, Your Honor, I want to push back on the premise of your question, because what we're arguing is consistent with the way the Federal Vacancy Reform Act defines exclusive functions. And there are statutes and there are regulations in which the Department of the Interior has made clear that, or Congress or the Department of Interior has made clear that subdelegation is not permissible. The district court quoted 5 of them in its decision. We provided a number of them in our brief. The government provided some others in their brief. It is the exception rather than the rule that something is not delegable. That is the choice that Congress made in the Federal Vacancies Reform Act. That choice applies uniformly to statutes and to regulations. And this court in the Mobley decision, which involved a delegation through an executive order, specifically said subdelegation to a subordinate federal official is presumptively permissible absent affirmative evidence in the original delegation of a contrary intent. The only thing they've pointed to here that they say is affirmative evidence of a contrary intent is the mentioning of the assistant secretary. But that's where it matters that there are two paths. There have long been two paths. If you look at the preamble for when this 2013 regulation was promulgated, it explains that the whole point of this is to apply the existing regulations for all ASIA and BIA decisions to trust decisions. And that is spelled out in 25 CFR 2.6. They're taking the same rules that have always been at play for these two paths, one of which is through the Assistant Secretary Indian Affairs Office. That's a secretarial office. You can see, if you look at the departmental manual org chart, you can see that the principal deputy is the second in command of everything that happens in that office. And then you have a separate path, which is through BIA officials. And the BIA is a separate bureau. It's not run as part of the secretary's office. And then there have always been these two paths. The Department of the Interior's Board of Indian Appeals has interpreted that authority as being delegable, the assistant secretary's authority, in two decisions. That is the Forest County Potawatomi community decision and the Rama Navajo chapter decision. District courts have interpreted that assistant secretary authority as being delegable. That's the Chattahoochee Tribal Nation decision from Connecticut, the District of Connecticut in 2008, and the Sokogon Chippewa community decision from the Western District of Wisconsin in 1996. Judge McFadden looked at all of these things, the longstanding understanding that the Interior has had about what is delegable, that it is consistent with FIVRA, that this is like Mango and Ethicon Endo in identifying an individual to make clear they have authority and to help spell out that there are these two paths, but not to preclude further delegation. And then you have the departmental manual, which since 2003 has made clear that the principal deputy exercises all of the authority that the assistant secretary has that's delegable. So you have all of these factors pointing in the same direction. You layer on that the Connor memorandum, you layer on that the two decisions by Mr. Black. There is every indication in this record that it was intended by Interior that this be a final decision, that Stand Up would be able to challenge that final decision in federal court, which they have in fact done. That they did not need to administratively exhaust. And that is really the point here is for parties to know, do we have to administratively exhaust or not? They did not. The government
how far do we have to go? We have to go to the manual, or do we have to go to the Connor decision in order to have, cross all the T's and dot all the I's?
Frankly, Your Honor, I think you can go to either. The district court looked to the departmental manual. I think the language is clear in the departmental manual. You can see—
Is there an exercise of the power to delegate, or is that just describing the power? In other words, don't we have to point to an exercise of that power, of the power to delegate?
So the departmental manual, Your Honor, when you look at it, specifically says that the principal deputy assistant secretary may exercise the authority delegated in 209 Departmental Manual 8.1. And so I think there is the language that you're looking for, and it is found in the departmental manual. The Connor memorandum, I think, is an alternative way of reaching the same conclusion. As Mr. Toth told you, the Connor memorandum specifically says that it is to confirm that Mr. Roberts had the authority to exercise the functions and duties that FIVRA allows to be delegated to him, the non-exclusive duties. The department intended him to have those. That is what he was exercising. And I would note the departmental manual was in place when this regulation was amended in 2013. So I think everyone's understanding from the government, if you look at court decisions, you look at the Board of Indian Appeals, you look at the way the secretary addressed this in the preamble, no one has ever suggested that there is a limitation in this provision on what the assistant secretary can delegate to the principal deputy. In 2005, just to make one more point on this, in 2005, the assistant secretary asked the Department of Interior's solicitor to identify all of the statutes and regulations that were the FIVRA duties. Essentially, what could the assistant secretary not delegate? And that memorandum from the solicitor is in the record, and it did not conclude that there was any limitation on the authority in 2.6, which was at the time what set out the two different paths. So I think that's yet another factor that the court can look to in understanding that there's nothing in the purpose, the text, the structure of these two paths that intends for only the assistant secretary to perform the act. As the district court noted, that would lead to absurd results, because one of the things that the assistant secretary is required to do, or the secretary, is to provide notice, to publish in the Federal Register a notice of the decision, and to actually acquire the land into trust. And there's no suggestion that really it has to be the assistant secretary who goes out and takes.
But that's I think a straw man. I mean, delegation is different than just having an agent do something for you. I mean, we issue decisions, and only we are authorized to issue decisions, but we have, a clerk's office that does it for us. That doesn't mean that we've delegated any authority to the clerk's office. I mean, the secretary does lots of things, and the secretary has assistants acting as his or her agents to do them. So
that's right, Your Honor. And the principal deputy assistant secretary is the person identified as the agent who is the second in command, and who, when there is a vacancy, has all of the assistant secretary's authority. So we think that's just further confirmation that here subdelegation is permissible.
The principal deputy has that authority for the time period that Congress says that person has that authority, right?
Well, Your Honor, I think there's an important nuance that maybe we're missing in our dialogue, which is that for 210 days, when someone is in an acting role, they have all of the authority for the exclusive and non-exclusive duties, all of them. They can do everything. Once that 210 days pass, they can no longer do the exclusive duties and functions. So there is a subset of authority they lose, but the remainder of the authority remains with them.
And you've told me that the department's view is that the assistant secretary has no exclusive duties, right? Not a single one.
No, that's not true, Your Honor. And I'm sorry if I suggested something to the contrary. The district court gave 5 examples of those at JA 340. We've provided a couple additional examples in our brief. For example, 43 CFR 3191.2 says certain authority relating to oil and gas leases, quote, shall not be redelegated. That is a clear example where the presumption of delegability would not apply because the regulation says otherwise. Similarly, 43 CFR 20-202B1 says that certain authority about imposing disciplinary action, quote, may not be redelegated. This is the kind of language that the solicitor was looking for. And if you look at the solicitor's memo from 2005, which is in the record at JA 286, the solicitor explains how they approach this question about which of the ASIA's delegated authority is further subdelegable and which is not. And in this,
I understand that. I guess I didn't state my question or comment properly. Nothing is exclusive unless the agency says it is. That's the position, right?
I think the strongest way for it to be clear is when the agency says it is. Giordano shows that there can be instances where the court may need to resort to understanding the purpose in order to reach that conclusion, or looking to legislative history to reach that conclusion. But this is not a situation where any of those factors that the Giordano court looked to are applicable. So although express language is one way, and the easiest way for Congress or for the Secretary to make it clear. I think there are other ways to overcome the presumption as well. None of them are met here. And again, this is like the Mango and the Ethicon Endo case, where the mere naming of an official is not a sufficient basis on its own to show that there is an intent to prohibit that official from subdelegating internal subdelegations. That's the line that this court has consistently drawn. Internal subdelegations that keep responsibility at the named official are presumptively permissible. When a delegation goes outside of the kind of internal chain of command, that's where this court has said that the delegations are impermissible. For example, in the Shook case from this court back in 1998, there was a situation where the Department of Education tried to delegate to an outside board of trustees. And what this court said was that was not permissible because it was not this kind of internal keeping accountability and responsibility with the named official. This is not that case. This is a case where the subdelegation was internal. It was to the second in command. It was consistent with the departmental manual. It was confirmed by the Connor Memorandum. It was further confirmed by Mr. Black in the new administration, agreeing that this was intended to be a final decision, citing the departmental manual to explain why Mr. Roberts had final decision-making authority, because he stood in the shoes of the ASIA for this particular action. And then Stand Up got their appeal. I mean, really, I think it's important to sort of step back and remember that the point here is to make sure parties have notice of how to appeal. And there's no question here, Stand Up got its appeal. It got to bring its NEPA challenge. It got to bring its CRA challenge. And those challenges were resolved by the district court. It got to appeal those challenges to you. So everything that the regulation was designed to do, which is to give notice of how to get judicial review of an action, was met. And so for all of these reasons on this and on the NEPA and the CRA count, we ask that this court affirm the decision below.
All right, thank you. We'll give Ms. McLean 2 minutes for rebuttal.
Thank you, Your Honor. Just a few points. The cases that counsel for Wilton Rancheria cite all relate to statutes. And so to the extent that there is any reason to treat them differently, and we believe that there is, including when a regulation is very specific and who is assigned what responsibility and the consequences of those decisions, the analysis that in those cases do not control here. I
don't understand why the statute would have a presumption, but a regulation wouldn't. I mean, I must say, I think it should be the opposite. With respect to a regulation, there's still a secretary, there's still a deputy secretary. Presumably, if somebody below them acts in a way that they don't want them to act, they can stop them. It's much harder for Congress to do that. So I don't see what the argument even is to suggest that the presumption doesn't apply with respect to internal organization of a department.
Well, when a department makes decisions as to the finality of...
I understand the finality argument, but the finality argument is, as they say, one about exhaustion. Usually, appellants are up here claiming, this is final, we want to appeal, we don't need to stay in the agency anymore, they're not going to give us what we want. And so this is usually a finality question. This is a benefit rather than a burden. And I haven't heard any respect in which you've indicated it was a burden. You discussed for some time the notice question, but I don't see how the lack of notice, if there was one, injured you in any way. You did what you would do if it's final.
Well, counsel for the department and for the tribe represented that we had our administrative appeal. An administrative appeal before the IVIA is different from an appeal in court, and also involves staying the transfer of land can't occur while that appeal is pending.
Okay, but that time has passed. I don't understand. You think you would have gotten a better deal from the Bureau than you would from is it the Bureau or the board? I'm confused, board.
Interior Board of Indian Appeals.
Yeah. Then you would from a court. They can't make a decision that's inconsistent with what the policymakers, from a policy point of view, think. So I don't understand how you would benefit from an internal appeal, and you certainly haven't told us how.
I think, well, one of the big issues is it mattered to stand up at that time because there were state proceedings pending. A California Environmental Quality Act case was pending. And by immediately transferring the land into trust, the citizens no longer had the right to pursue the claims that they had in state court because the state court lost jurisdiction. So from their perspective, it was important that if a final decision was going to be made, it'd be made by a PAS officer with the authority to make that decision so that they could continue their state proceedings while they also proceeded to appeal the NEPA documentation.
Is there any indication in the federal notice that established this sort of dual approach that the purpose here is to provide that opportunity rather than to just provide notice of when something's final?
Well, the regulation is very clear that only a few decisions will be handled by an assistant secretary because those decisions raise significant policy questions and require additional layers of review. The purpose of the regulation wasn't simply to indicate whether a decision was final or not. It also creates other obligations. For example, the immediate transfer of land into trust, which occurred in February. It also requires publication in the Federal Register, which never occurred at all. The department has never actually published notice of this decision per the regulations. To the extent there was question about
you knew of the decision, so that I appreciate the general value of publication. But generally, when somebody makes a complaint that it wasn't published, that's for the question of whether it's final yet and whether or not they're injured by lack of notice. And both of those are taken care of here.
Well, and
I'm not sure. It'd be one thing if this was a rule that's going to go on and follow, apply to others, but it's not. It's a decision in an individual case.
Well, I do think it's a rule that will apply to others, Your Honor, in the sense that you have a regulation, 25 CFR 2.4, that says any decision by a deputy is non-final and subject to appeal to the IBIA. You have 2.6 that says only decisions by the assistant secretary are final. And you have 25 CFR 151.12 that the defendants concede is intended to mirror those appeal regulations, which a district court in California interpreted as being exclusive. And so I think that there is a very real public interest in ensuring that before the department makes a trust decision and immediately acquires land and that would precipitate the immediate acquisition of land and trust, it be done by an official that has the authority to do it. And in this case, what the regulations establish is that that person should be a PAS officer, the assistant secretary. And it's very clear in the preamble to the rule that only a few decisions are intended to be made by the assistant secretary because those decisions are important, and all others are intended to go to the IBIA so that the department can ensure that its decision making is consistent and people can get their administrative appeal rights satisfied. So I do think there's a very important interest here.
Okay, are there further questions?
Thank you.
Yeah. Thank you very much. This was another very good argument today. We appreciate it. Thank you.
Thank you.
We'll take
This honorable court is now adjourned until Tuesday, November 10th at 9:30 a.m.